Okay, good morning. My name is Kelsey Beckner, and I have my own law practice, Beckner Immigration Law. And I did a prior training on an introduction to asylum law, and today I'm going to do a follow up on more logistics and how you prepare an asylum case and kind of a step-by-step of asylum cases in the United States. Um, so hopefully what we'll get through today is what is the process, what form do you use, what evidence do you need, what do you do to prepare your client, and then there will be some more details in there as well. But really, I would like you to feel comfortable answering these questions by the end of this presentation. Uh, so the first thing we're going to talk about is the process of filing an affirmative asylum application. And people who file affirmative asylum applications are people who arrive in the United States and are not put in immigration proceedings immediately. So those are mostly people who have come here on a visitor visa and then they decide to apply for asylum, or they're here on a student visa or any really type of visa. You can apply for asylum in any status, basically. Even permanent residents can technically apply for asylum, whether they need to or not. I mean, most of the time they don't need to, but basically you can be in any status and apply for asylum in the United States. But not everybody can apply affirmatively. So how do you file for asylum? The main way you file is you go to uscis.gov and you download the form I-589, which is under the forms bar on the uscis.gov website. You download that form and you fill it out the best you can with your client. And if you follow the instructions of the form, which are also in that same website, and you send the form in compliance with the instructions, then that's technically all you need to do to apply for asylum affirmatively. But I recommend doing some other things. Next slide. So, and I will talk a little bit more about other things you need to do to apply. Usually when I submit an asylum application, I submit a declaration with my clients and submit other corroborating evidence and proof of identity and a bunch of other evidence. But just to get the asylum application started, you file the form I-589. So after you file that form I-589 with the correct address, which you will also find on the uscis.gov website, I recommend that you double check that address before you send it, because it does change and sometimes they don't tell us that it's changed. And so just double check the address where you have to send it before. Double check that you also double check also how many copies you have to send. You always have to send the original, and you used to have to send 2 copies in addition to the original, but now you have to send the original plus 1 copy. So, but again, that could change. So just make sure that you've double checked that before. And if you have a family, it also gets a little bit complicated because you have to submit a copy of the application for each family member included. So your packet could get pretty big, even with just filing just that form and identifying documents or identity documents. So after you file the form I-589, you'll get a small blue carbon copy receipt called the acknowledgement of receipt. And there will be a case number starting with the ZSF. That's for the San Francisco Asylum Office, and that is your asylum case number. So when you correspond with the asylum office, you need to have that number ready, because that's how they identify the case. And then your client will also be assigned an A number. That's a 9-digit number that basically will be their number throughout their immigration proceedings, at least until they become a U.S. citizen. So that number is very important and my clients don't always understand what it is, but I make sure to let them know that that is an important number for them to know. And then after they get the receipt notice, all the applicants, whether it's spouse and the kids, will all have to go with their to the local application support center, which is usually at the USCIS office. Here in Seattle, it's in Tequila, and have their fingerprints taken. And the little kids, if they're kids under 14, just or under a certain age, they just have photographs taken. They don't have fingerprints taken. But that is the next step that everybody has to do. And some people get nervous about it if they've never been to the USCIS office before, but it is just kind of a normal part of the process that they want to have your biometric information and then be able to confirm your identity for later in the process. Next slide. So after you submit the form I-589, you wait for the asylum interview. For about 4 years, the asylum interviews were taking a long time to be scheduled. We were just waiting and waiting for asylum interviews to be scheduled. But as of February of this year, they changed the priority of asylum applications. So before, they were taking the applications that were filed the longest time ago, and they were interviewing those people. Now they're interviewing the people who applied most recently. So if you're preparing an asylum application now and you're submitting it to the San Francisco Asylum Office, you can expect an interview, I would say, fairly quickly. We're still getting reports that they're not happening immediately, though I do have clients who, I have one client who applied in February, was interviewed in March, and then her case was referred to the immigration court, and she already had her first hearing in immigration court. So that was very fast compared to how it's been the last few years. So like I said, the San Francisco Asylum Office is the office that has jurisdiction over interviews in Washington State. They come here on circuit rides, so they're not here all the time. And so that's part of the reason that it just takes longer for an interview to be scheduled in Seattle, because we don't have permanent asylum officers here. The asylum office director has put it out there that if you really want to go to San Francisco and be interviewed, you can contact the office and try to be interviewed in San Francisco. But I have to work that out with your client to make that happen. There is a bulletin that says when the asylum offices around the country are scheduling interviews, so you can look that up. That does have the San Francisco Asylum Office on it, but it doesn't list cases in Seattle. So usually the San Francisco Asylum interview timeline is informative, but definitely when we have cases interviewed up here is different from that. So it's all very unpredictable at this point in time. Next slide. So like I said earlier, the Form I-589 is enough to apply, but really to have a successful asylum case, you need to have other evidence to support the application, because as we discussed in the last training, it's about meeting the statutory elements of the case, but then there are also requirements for corroborating your asylum application and credibility, and making sure that the officer believes what you're saying and believes your testimony. And we haven't talked about credibility, and we haven't talked about corroboration and some of those detailed requirements. So I recommend reading up about those when you have a free moment. But in general, we just need to make sure that our client is credible and that they corroborate what they're saying. That being said, a credible declaration by the applicant is enough to get your client asylum. So The testimony has a lot of weight, so I usually spend a lot of time with my client working on a declaration, preparing the declaration in whatever way works best for my client, and focusing on specific details of the claim that I think are important. And then I submit that in advance of the interview. And um, most asylum officers think that's very helpful because it helps them frame the case. It helps them know the questions that they really need to focus on in the interview. From your client's perspective, you also then need to be consistent with that declaration that you presented. So for a lot of reasons, that declaration is very important. And I should say that there are definitely attorneys who may not do declarations with their clients because they don't want their clients to be caught in inconsistencies, or they're just not very good witnesses. And so they've decided it's better to not present a declaration. So that is kind of on an attorney by attorney basis. But in my training, in my practice, I found that it's very important part of the applications I do for people. You can also get declarations by family members. So if you have family members that were witnesses, you know, whether it's a spouse or children who are old enough to testify, you can do declarations with them, or they can write letters, kind of a little bit more informal testimony. Any other witnesses that were there who are willing to write a declaration or a letter. And usually if you have other people write these declarations, I recommend that you then have them submit proof of their identity with it. So their passport or birth certificate or some type of ID to just confirm that they are in fact a real person writing the statement. And then other corroborating evidence, usually what this comes down to are police reports, medical records, any type of evidence that you could think about like would be from an independent agency that, you know, might have kept a record of what happened. And some countries are really good about keeping records, and others they just don't really exist. And so if your client is from a place where, you know, they've really good about record keeping and it's pretty easy to get those records, then, you know, I would put a lot of emphasis on trying to have your client work with family members in their home country to get those records. If it's not possible, you know, document why it's not possible in your efforts to get those, because the asylum officer will want to know, and later when you get in front of the immigration judge, they'll want to know that you made an attempt to get evidence and why you weren't able to present that evidence. So another thing I do for my clients is I organize a psychological evaluation for them. I tend to do this more with the immigration court than with asylum office. Asylum officers are actually very well trained, and they, you know, I think evaluations are helpful for certain situations for asylum interviews. I don't think they're really as necessary as an immigration court, just because if your client has a strong case and really testifies pretty well, then it's, you know, the asylum officer doesn't really need it necessarily. But it just depends on your client. If your client has a lot of PTSD or really shows signs of depression and that's affecting their ability to testify, or they filed late, they waited 3 years after they came to the United States and they didn't file for asylum in that time, a psychological evaluation in particular is really helpful for explaining why they might not have filed sooner. And then if your client has kind of medical evidence, scars, some type of thing that they can show that's evidence of what happened to them, then I usually also schedule an exam by a doctor. And Refugees Northwest here in Seattle is pretty amazing. They have a network of evaluators who do these evaluations. I'd say the doctors are a little bit easier to get at this point, just because I think the exams are pretty straightforward, and they're able to do the exam pretty quickly, the evaluation pretty quickly. The psychological evaluations are definitely taking longer. They're way more in depth. They take longer for the psychologist to produce. And so, you know, I think if you are under limited time and there is medical evidence of the persecution, the typical, I think, example is if your client has had female genital mutilation or has other scars from things that happened to them. I had a client who was kidnapped, and while she was being held by her kidnappers, they cut her leg in multiple places. And so I had a doctor evaluate those scars and say that, you know, they were consistent with her testimony. So especially for female genital mutilation, I think it's necessary to have a medical exam. And then country conditions evidence, which I'll talk a little bit more about later. Next slide, please. So timing of submitting this evidence. So, you know, what I would recommend now at this point in time is, if you're preparing an asylum application, is that you prepare it all together when you're preparing the form I-589. But you also have to look at how long your client has been here. Have they been here 11 months and 15 days, and they only have 15 days to file their I-589 before they meet their 1-year deadline? If that's the case, you can just, you know, file the I-589 and say you're going to submit more evidence as soon as possible. And I would, you know, keep working on it right after that, because in this period of time, you're not going to have a ton of time to submit supplemental evidence. If you do just submit a kind of what we call a bare bones I-589 with no real evidence, you can email it to the asylum office in advance of the interview. I like to prepare it and then just have it ready for when I get the interview notice, and I submit it right before the interview, because I know then, you know, the file's been pulled, and most of the time the evidence gets in the file. So I know that the people are going to be reviewing it, so I like that it will be all kind of fresh in their mind when I send it. So I mean, the other thing about preparing the form submitting everything with the form I-589 when you file is that if you're taking the declaration and, you know, what happened was very recent, you really are optimizing the chance of everything being fresh in your client's mind, versus if you wait a few years, it just may not be, the details may not be there. They may have intentionally suppressed those memories, and then you're actually increasing your chance of re-traumatizing your client again. So I try to take declarations kind of as soon as I can, and have them ready to go. But you have to also figure that out with your client, what works. Okay, and then the benefit of waiting until you get the interview notice is that you're presenting evidence that's current, that's up to date. You know, they decide the asylum application based on when it's adjudicated. So it's possible that when if you filed a few years ago, and at that time your case was really strong, but, you know, since then the conditions have changed, and maybe now the case is a little bit weaker, you'll need to update that fact and address it. One example that comes to my mind is in the Gambia, you know, FGM has been kind of a rampant practice, and actually the president of the Gambia made FGM illegal a couple years ago. And so I had a client who was interviewed right after that, and I had to address the fact that, yeah, it may be officially illegal now, which was a change, but you know, it hasn't actually changed the practice. So um, just thinking about making sure you present up-to-date information is important as well. Next slide. Okay, so what needs to be in a declaration? When I talk to my clients about their declaration, I tell them it's their opportunity to tell their story. It's their chance to present what happened to them. You know, it's like an empowering thing, not something that needs to be overwhelming. And I stress how important it is that if it's a really good declaration, it can make a big difference in their case. So most declarations, all declarations I do, and this is just how I was trained, I submit with short numbered paragraphs, and I try to have every paragraph discuss kind of one thing. I don't like my paragraphs being too long or too short. So, you know, there is a lot of kind of, as I'm working on the declaration, moving it around, and then going back and re-editing and adding details. So, but in general, I do short number of paragraphs, and then the applicant needs to sign the declaration, and then at the end, they need to sign that everything was true to the best of their knowledge under penalty of perjury. So there's standard language that I use for that. And if you have an interpreter who helped you prepare the declaration, then I have the interpreter sign as well, saying that they translated the declaration to them in their native language. And that's also very important, that you let the adjudicator know that the declaration was prepared with an interpreter. You know, it puts the adjudicator on notice that they're not really able to talk about their claim in English at all. Yeah. And then I like to take declarations that are chronological. So I usually start with what happened if they're in their childhood, and then I go on to, you know, relevant events, the persecution, and usually the end of the declaration addresses why they're afraid to return to their country, why they couldn't live anywhere else, why the police can't protect them, kind of these future fear of persecution issues. Next slide. And how do you take a declaration? I usually schedule at least, I don't think I've ever done a 1-hour appointment declaration. So I think usually I do 1 or 2 2-hour appointments to take the declaration. And, you know, sometimes starting with kind of childhood events makes it easier for people to talk about. You kind of have to figure out how to build trust and have your clients open up to you about details as you're going. Some will be just ready to tell you the story, and have so much to say about everything, because a lot of them have never told it in this way. So, you know, some you'll just be like typing if you're the one typing, and I'm usually the one just typing what they say. Sometimes you'll just be typing, you really won't have to ask a lot of questions, and other people will just really be reserved and you'll have to probe them a lot. So I try to start with open-ended questions, guide them, and then guide them to more specific questions. And then I also try to build on details they've given already. And, you know, and sometimes I really have to push them for details that they don't want to talk about, but I know are important to their case. You know, for instance, a lot of my clients who have been victims of domestic violence they say, oh, then he hit me. Then my husband hit me. And I say, well, how did he hit you? Did he use something to hit you? Where did he hit you on your body? How often did that happen? What was the circumstances under which it happened? So I really try to get some of those specific details about those circumstances that people usually don't like giving. And in general, you really, I think, you want to focus on kind of one of the first times things happened. If it was kind of this repeated series of events, the first time something happened, and then like specific events that were really bad that kind of stand out in their mind. And then I usually give a more general statement about, it happened, my husband would come home drunk and, at least 3 times a month, and we would start fighting, and then he would start hitting me, and every time I went to the police, and that continued for years, so that you're then creating a timeline of events and having them address the fact that this persecution happened for years, but then not having them give every single detail about every single time it happened. And then I think it's important to not be afraid to ask clarification if something doesn't make sense to you. You are, at least in my perspective, you are also a devil's advocate in addition to being their advocate. So, sorry, I'm just gonna close my door. Okay. Sorry.
No problem.
3, 2, 1, go. So you are a devil's advocate. So if something doesn't make sense, if they say, oh, well, this happened in 2013, and then they talk about their child being born in 2015, and they were, like they said that they were pregnant in 2014, and you're like, hold on, the math really doesn't add up, or just things don't really make a lot of sense in your mind. I think it's fine just to have them think it through a little bit and make sure that they're not just fabricating dates or because they think that's what you want. You really want to have them give you details that they'll remember, that they can then recall later, and that they can talk about. So if you realize that as you're going on that your client really doesn't remember dates, doesn't have a good timeline in their head, then don't focus too strictly on the timeline, or don't really talk about dates if they're not necessary. So and that's something that you'll figure out as time goes, as you do more of these, and also as you get to know the client. So next slide. So okay. So actually what I had a training like that I did with some other people, and so we talked about questions that you would ask to take a declaration, and you can do this if you want. You can think of, okay, this actually may be a very common scenario right now for people from Guatemala or Honduras or El Salvador. They come into your office, they give you their name, they say they're from Guatemala, they want to apply for asylum. So where do you start? And for the I-589, I always start with, well, did something bad happen to you? Are you afraid of going back to your country? Who are you afraid of in your country? Kind of these general questions about what happened to you, why did it happen to you, and what are you afraid of? And then for the declaration, really thinking about getting into a lot more detail about what happened and why it happened. And hopefully, as you're working through this, your client will tell you things that will be admittedly awful things that happen to them, but that will also end up being very good things for their asylum case. And so next slide. Okay. So getting other corroborating evidence. So in addition to doing the declaration, I usually sit down with my clients and go through, as I'm going through their case, you know, sometimes while I'm doing the declaration, even I say, oh, you know, you're talking about a police report. Can we get that police report? Or you're talking about how your sister was there and witnessed what happened to you. Can we get something written by your sister? So, you know, first, some clients will have stuff that they brought with them. So look at what they brought with them. Like I said, this really differs from country to country, because some people just have a lot of paper and others really have nothing. And if they don't have evidence with them, do they have family members in their home country who can help them get documents? So that involves just having a frank conversation. Like, these are things that would be ideal for you to get. Who can help you get it? Do you have, you know, can your parents help you get it? Do you have friends who can help you get it? Is there any other way that we can get this evidence? And sometimes that requires a lot of creativity. And sometimes you work really hard to get the evidence and you get it, and it's not that great and it's not that helpful, but you at least need to try and work with your clients to think through these things, because they're expected to have some corroborating evidence. Next slide. So, and I talked a little bit earlier already about the psychological evaluation and the medical exam, and I really actually can't stress how important these are, especially for cases in immigration court. I think they're really, really important, because then you can have the doctor or the psychologist or therapist, counselor, whoever they are. I always ask them to come in and testify for my client, and most of them are, so what they are doing is expert testimony. And as experts, you know, we have to give deference to their expertise. And so I really like having people who can say, look, this person has PTSD and it really affected their ability to do this in their day-to-day life, and it affects their ability to recall details correctly. So I think that those are very important to get. And so basically, as soon as you finish the declaration or you have a good idea of the story, I would recommend contacting Refugees Northwest, or if there are some psychologists who will do it on a low bono basis, on a sliding scale basis. Some are quite expensive, but you know, I know that there are a lot of actually people out in the community now who are trained to do this and want to help. So definitely is something that you should try to get for your client if you think it will benefit their case. Next slide. So country conditions evidence. This is, I actually think this is really fun to do because you get, if you have time, you get to research what's going on in the country where your client is from. And, you know, to figure out how those documents can support their case. So what I usually do is I do really detailed internet search. I don't know how people did it before the internet, but we're really lucky to be working in an age where we have so much access to information. I guess in another way, it could also hurt our client's case because there's now, you know, so much information available that could then not support our client's case. But, you know, as an advocate, I have a lot more time to present really detailed, specific arguments to my client's case than the government does. So this is really where a place where you can support your client's case in a thorough, objective way. And I think the main thing that people have relied on is the U.S. Department of State Human Rights Report. I used to submit them. I don't actually submit them very much anymore, though I do. When I do, I submit excerpts of the reports that are relevant to my client's case, because they are really long and they take up a lot of room. I really like to focus on things that are very, right on point to my client's case, and I won't just submit the 2018 Human Rights Watch report for Mexico just because, I'll submit it if I think it helps my client or it addresses a specific issue in my client's case. But I won't just submit them. And actually, asylum officers are very familiar with these sources, so I don't really want you to resubmit the U.S. Department of State Human Rights Report again. It's just like more paper for them to read. It's really not necessary, particularly for asylum officers. I think more important for them are just, your really detailed research on New York Times, like different articles or reports by different organizations that they may not find in kind of a casual search, or that they may not have gotten when they were trained on that specific country. So that's what I recommend doing. And I tend not to submit, hundreds of pages of evidence. I like to, if I'm over 200, I start getting a little nervous that it's too much, because I really want them to read what I've submitted. So usually it ends up being maybe like 100 to 200 pages of country conditions evidence. And if you really can't find anything that is super helpful, you may need to find a country conditions expert. How you find a country conditions expert is an interesting question. There are some experts that are kind of well known in the immigration community who you can just, send an email to other immigration attorneys and they'll say, oh yeah, I've used this person before, he's great. Or sometimes you have to do your own research. Look at the University of Washington, is there an expert on gender violence in Guatemala? And then email them and say, are you willing to be an expert for this case? And that may take a little bit more handholding if they've never done it before, because they're just not familiar with how it works. But, if you have time, I think a country conditions expert can really help, especially with these Central American cases, where even though the violence is so awful, we really need to go kind of above and beyond to convince judges and asylum officers that they should be granting the case. Next slide. Okay, so you've submitted your I-589, you've ideally submitted most of the evidence with it, you've waited 3 years, and all of a sudden you get your asylum interview notice. And it also is a little blue carbon copy piece of paper, just like your acknowledgement of receipt. So when you see a little piece of paper like that, you can have an idea, well, this is maybe my client's asylum interview notice. So basically from the date it's sent, you have 21 days. And if you haven't submitted the declaration and submitted the other evidence in that time, you have to work very quickly to make sure that you finish up that information, that evidence, because the local rule is that materials need to be received in San Francisco by the Monday of the week before the asylum interview. So basically, you have to send your evidence down to San Francisco almost 2 weeks before the asylum interview. So really, you only have a week after you get your notice to get everything together. And you need to make sure your client has an interpreter for the interview. Your client is responsible for bringing the interpreter. So if your client doesn't have a friend or a good family member or someone who's competent to do it, you need to help them find an interpreter, see if they can pay for the interpreter. I have to say that it's really worth it for your client to pay for an interpreter if they can. because bad interpretation can be just as bad as your client testifying poorly. So, and I really highly recommend finding a professional if you can, if your client really doesn't have someone else who's good for that. And then I usually have 1 to 2 meetings with my clients to prepare them for the interview. And sometimes I act like I'm the asylum officer, and I practice the questions and see how they do answering the questions. And if they do have an interpreter lined up, also practice with the interpreter. So the interpreter is used to the material and is also comfortable doing the interpretation as the asylum officer wants it to be done, which is not, I think it's called consecutive interpretation. So the person interpreting has to be comfortable saying everything that both of them are saying, which can be hard if you're not a professional. Next slide. So what happens at the interview, and this is similar to what happens at the credible fear interview and at the reasonable fear interview, which I'll discuss in a little bit, is the client and interpreter will sit opposite the asylum officer, and the client will answer questions. And basically here in Seattle, they're in an office, the asylum officer is behind a desk, the client and the interpreter are sitting next to each other, just opposite on the other side of the desk. The client has to swear an oath to tell the truth. The interpreter does as well. Most of the time, the officer will call another interpreter to check the interpretation to make sure they're interpreting correctly. The interview is supposed to be non-adversarial, which means that the asylum officer is supposed to be friendly, not supposed to like make it a confrontational situation or start making accusations. And in general, in my experience, they are non-adversarial, and the asylum officers want the applicants to be comfortable, to feel like they can talk about what happened to them. They don't want them to be too stressed out, because then they're not going to testify well. So the asylum officers also, in a way, want what we want from our clients, which is just to be able to testify really well about their cases. And they have received training about, trauma and how it affects people, and in general, they are very sensitive to how people are affected by traumatic events, and they know it's hard for people to talk about things. In my last interview, my client, when she was talking about the worst thing that happened to her, she said, I actually can't talk about this. I need to write it down. And so the asylum officer gave her a piece of paper and let her write it down, and then the interpreter read that what she wrote. So they really want to get the testimony the best way they possibly can. The role of the attorney is to not participate really in the interview. So I usually sit behind the applicant and the interpreter, and I take notes. And while there's a part of the interview where we're reviewing the asylum application. So while we're reviewing the asylum application, I usually chime in if there's like an update that my client didn't provide, or if there's something that we want to change. I will usually talk a little bit, but I am mostly just sitting back and observing and taking notes. And then at the end, if I have the opportunity to ask questions and give a statement. And so if my client has missed something, not talked about something, the officer didn't ask about something I thought was important, then I will ask questions. And I've never really been limited in how many questions I can ask, but I haven't had to ask a ton of questions, because usually the officers are pretty thorough. Next slide. Oh, next slide.
Oh, I know. I'm
Oh.
There we go.
Oh, there you go. Okay. So the officers will tell you, tell the applicant at the interview, you know, we'll have a decision in this amount of time. And this varies around the country because some asylum offices, they have you come and pick up your decision. Here in Seattle, you are mailed your decision. So if you actually are in the San Francisco asylum office, they have you go and pick up your decision. So I think they get their decisions a little bit faster. I've tended to get asylum decisions anywhere between a month after the interview and 2 years after 2 years after the interview. The 2 years was an extreme situation. I'd say most of them come, you know, between, I would say, a month and 3 months is how long it takes. And you know, when they get the decision, either the asylum office will grant asylum, and sometimes if the security checks have not cleared, what they get is a recommended grant of asylum, which is kind of like, we think we're going to grant you asylum, but we just need to get through these security checks. And I do have a client who was recommended asylum, and then 2.5 years later, he finally did get asylum after his security checks cleared. So that, you know, and in that case, he was actually interviewed a second time, and those asylum officers said, we're not trying to re-adjudicate his case. We just need to make sure that we've cleared everything. And so that, you know, when they said they recommended asylum, they really meant it. And the other option, if they are not granted asylum or recommended a grant of asylum, is that the asylum office will refer the case to immigration court. And so what they'll get, instead of asylum approval, at the top of the letter, it will say referral notice. And the reason that cases are referred to immigration court are usually if the person is out of status, and, you know, basically their asylum application has been or their asylum application has essentially been denied by the asylum office, but because they're out of status and they know that they can renew their application in front of the asylum judge, they're referring their case to the asylum or the immigration court. And they will state in the referral notice the reasons that they're referring the case to the immigration court. So those are kind of the reasons they're denying. There are some people who do get denied asylum, and those are people who are in status when they apply. And so, like, for someone on a student visa, they are on a student visa when they apply. They're still on their student visa when their case is denied. They'll just get a denial and they'll just go back to being a student. They don't get sent to immigration court. Next slide. So if your client is granted asylum, which is one of the best things about being an immigration attorney, your client is supposed to get a new work permit based on having an approved asylum application. The asylum office should send you this little card called an I-94 card with the approval notice. And that I-94 card basically says that you're granted asylum indefinitely. And those two documents are proof of asylum status that they can use to get a job, get a new social security card, get other benefits that they're allowed. And they are allowed some benefits. In particular, they're eligible for medical benefits, food stamps, some housing benefits, educational benefits, employment assistance. So if your client does get asylum, you know, I always try to at least give them information about how they can access those benefits, though I think it is beyond the scope of my representation to help them get the benefits, but I do always help them get their work permit cards and I-94s if they haven't gotten them for some reason. And then after 1 year, the asylee can apply for a green card. So basically the asylum grant will say, you, as of this day, you have asylum. So 1 year from that day is the day that they can apply for their green card. And sometimes they'll come back to you and say, well, can I apply early? And you'll say, no, you can't apply early. You just have to apply on that 1-year deadline or after. Okay, next slide. So what if the client's referred to immigration court? So with the referral notice, they'll issue a document called the notice to appear, and then they will file that document in immigration court. And I should note that the notice to appear was the subject of a recent Supreme Court case called Pereira. And basically that court case said that if the notice to appear didn't specify the date and the time of the hearing, then it's not a valid notice to appear. And so I would say basically almost all notice to appears that have been issued probably over the past however long period of time don't have a date and a time for their hearing. And so that is just something to look at when your client gets referred to immigration court, to be aware of, because you may want to talk to them about trying to terminate the immigration court case because there wasn't a valid notice to appear. I assume that going forward they will rectify this and figure out a way to put a date and time of the hearing on the notice to appear. But if they don't, it's one thing to know about. So once the case is filed in immigration court, basically it's a jurisdictional shift from the Department of Homeland Security to the Department of Justice or Executive Office of Immigration Review, and specifically to the immigration court. And once your client's case is in immigration court, you can renew your asylum application in front of the immigration judge. And then it will be the immigration judge's decision to decide whether your client qualifies for asylum. Next slide. So before I getting too much into immigration court stuff, I wanted to take a quick step back to talk about credible fear interviews and reasonable fear interviews, which are interviews that occur when your client is in immigration proceedings or has been apprehended or is kind of in this process. You know, they can't do affirmative asylum because they've been apprehended at the border, or they presented themselves at the border, or they were deported and came back to the United States and they're also back in custody. Basically credible fear interviews, and these are interviews you're hearing a lot about on the news, are interviews that happen right after someone has presented themselves at the border and has expressed a fear of returning to their country. So you can present yourself at the border, and if you don't say anything, you don't say anything about being afraid of going back, then basically the US government can just deport you if they find that you're deportable. But once you express that fear, then the government is obligated to do a credible fear interview and assess your fear of returning to your country. And credible fear interviews are kind of like asylum interviews light, in the sense that they're supposed to be non-adversarial. There's still this kind of limited role for the attorney. But in my experience, they are a lot shorter, and the asylum officer usually writes the transcript as they're going, and then gives that transcript to the person right after the credible fear interview is done. And usually a lot of it is done telephonically. So sometimes the asylum officer is not even in the room with the person, and sometimes the interpreter is not in the room. So it's just like the applicant sitting in a room with a telephone. And that's just because, if you imagine your client being detained at the border, or here at the federal detention center, the ability of the asylum office to get people to do those interviews it's a challenge for a lot of reasons. And so they a lot of times resort to doing things telephonically, and because they have so many to do, they just don't get into detail in a lot of questions. I think they basically are like issue spotting. If your client says, this is why I'm afraid, and tells them right up front why they're afraid of going back, then they can basically conclude their interview. But if not, then they'll just say, well, you don't have a credible fear of deportation or of returning to your country, which is why preparing people for credible fear interviews is very important. And I have done that on the border before. I know people are doing that here for the federal detention center cases. Just meeting with people to talking with them about what they have to say, what's important for them to talk about for their case, and really helping them focus on the details that they need to talk about, because they don't have a lot of time, frankly, in those interviews to present what they need to talk about. And there are some FAQs on credible fear interviews at uscis.gov. Next slide. So after the credible fear interview, if you're found to have a credible fear by the asylum officer, then the applicant basically gets a chance to present your full asylum claim to the immigration judge. And in the past, they've usually been released from detention after that finding. And in the past, honestly, I would say, probably 80 or 90% of people pass their credible fear interview, because it is a low bar to pass the interview. You basically just need to present some evidence of the fear that you have, and they will usually pass. And that's unfortunately not what we're seeing today anymore. And I'll talk about that in just a little bit. But if you're not found to have a credible fear, then the decision is reviewed by an immigration judge. And if the immigration judge agrees with the asylum officer, then basically that's the end of the road. When I have done these cases at the border, what we did in this situation is, if the immigration judge agreed, and a lot of times they don't reverse the finding of the asylum officer. I have then gone back to the asylum office and asked them to reconsider their credible fear decision, pointing out new information that the client was initially afraid to give, or really didn't feel comfortable discussing with someone she just met for 15 minutes the day before. So it was like very, very kind of private information that understandably people aren't comfortable about talking about with strangers. But once they realize, okay, I'm going to be deported if I don't talk about this, then they can give that information. And once you have that new information, you can ask the asylum office to reconsider, and they may reconsider, and then they may do a new interview and find the person has a credible fear. And I did have that happen when I went down to Texas and was at the Dilley, the family detention center in Dilley. So it's possible it may be harder today than it was back then. Next slide. So the other form of interviews, so you'll hear about CFIs. The other one is RFIs, reasonable fear interviews. So these are interviews for people who have a prior order of removal and then they re-entered the United States. So these are people who have somehow been deported in the past. They weren't voluntary, they didn't receive voluntary departure or voluntary return. They were deported or ordered deported by an immigration judge. And then they left, and then they returned illegally to the United States. Or they presented themselves again at the border. And so because they have this prior order of removal, they're actually not eligible for asylum. They are only eligible for withholding of removal, which is a lesser form of relief. But instead of doing a credible fear interview for these people, they do a reasonable fear interview. The standard is a little bit higher because we're talking about withholding of removal. But it is still fairly low, and I don't think it should be too high. The constant pressure to make it harder and harder to pass these interviews, and then it's our job to push back and say, actually, this is what the law says, that if they express this reasonable fear of persecution, then they should get a chance to go in front of an immigration judge. There are some more questions and answers about reasonable fear screenings on uscis.gov. And I also included the regulation there, which just one regulation, it's really, there's not hard to read. There's it's so short, and it's, if you are doing an interview like this or have a case like that, it's really important to understand that regulation. If the asylum officer finds they have a reasonable fear of return, then the case is referred to the immigration judge, and the person is put in withholding only proceedings. That means that they're not applying for asylum anymore. They're only applying for withholding of removal or relief under the Convention Against Torture, which are lesser forms of relief, but they are still will prevent you from being deported to your country. If you're not found to have a reasonable fear of return, then the case is referred also for review by the immigration judge. But if the immigration judge agrees with the asylum officer, then you can be deported, and probably will be deported pretty quickly, unless you file a petition for review with the Ninth Circuit. And the important thing to note is that there's no direct appeal to the BIA of a negative review of an IJ of an RFI decision. Very important to know, it's one of the very few circumstances when you can't appeal an immigration judge decision to the BIA. Next slide. And so what happened 2 days ago was that basically USCIS issued guidance on how officers should process reasonable fear, credible fear, asylum and refugee claims following this case that I talked about last time, matter of AB. So I put the site to that guidance that was just issued. I really recommend that you read this guidance if you are doing CFI interviews, or CFIs, RFIs, asylum interviews, where your client has a domestic violence claim or a gang violence claim, because you need to see how USCIS has been instructed to review that claim, and then make your best argument about why your client doesn't fall under AB, or why your client still has a valid claim in spite of AB. So this is the most recent piece of devastating news that our community has received. Next slide. So switching gears just a little bit to immigration court in general. There has been some really interesting research on basically the luck of where your case lands in the immigration court system. There's this study, actually it's a Syracuse University, it's called TRAC, T-R-A-C. They basically monitor all the decisions of asylum judges or immigration judges on asylum decisions. So when you know what immigration judge you have, you can go to TRAC and see what their grant rate is. And Refugee Roulette was a study done by Georgetown University Law Center, which basically said, it's all about luck. You could, if you end up in New York in front of a judge with a 90% approval rate, you're lucky. If you end up in Atlanta with a judge who has a 99% denial rate, then you're, again, it's really about the odds of where your case ends up, and if you end up in front of a judge who has a really good grant rate or a really bad grant rate, and it really is all over the place. Here in Seattle, we have 3 judges right now. One of them is kind of on permanent leave, Judge Walsh, and he's been having other judges fill in for him over the summer. And so every week we have a new immigration judge filling in for him, which is kind of keeping us on our toes. But in general, I think the judges here in Seattle are pretty good. I think they have about 40 to 50% approval or grant rate, which is not bad. And there are also 3 judges in Tacoma, and some judges are filling in there as well. And so some of the judges in Tacoma, I think one is better than others, and so it really just, you need to learn about your immigration judge, learn about how they do cases, look at their grant rate, talk to other people who've had cases before them, and really see what they like to see, you know, what is convincing evidence to them, and really understanding how that judge works and how they like their cases presented. Next slide. So yeah, this is just more information on track immigration, and here's the site. And so specifically, you can see in the asylum immigration court, you know, if you were unlucky enough to be in front of Judge Harris, you had a much lower chance of having your asylum case granted. Whereas Judge Schmidt, who has since retired and writes an amazing blog on due process issues, he's great. I highly recommend reading it if you have some free time. But he had an 83% grant rate when he was at the asylum immigration court. And you can see you know, the same kind of spread with Los Angeles. And I think if you look just between the different courts, you'll kind of see this with all the courts. Next slide. So asylum and immigration court is not the worst thing in the world. I prefer to have my clients granted in by the asylum office, but if your client's case is in immigration court, which, you know, if your client is has passed the CFI and gets referred to immigration court that way, it's great to be in immigration court, because then you're still here fighting your case. Oh, go back one. Okay. So basically, you have another chance to present your case to the immigration judge, and the review is basically the immigration judge doesn't really look at the prior adjudication. Sometimes the Department of Homeland Security attorneys will raise prior adjudication by the asylum office in immigration court, but if they don't, you know, it's basically like you're presenting the client's case the first time. So it's like you get a second new opportunity. You can update the I-589, you can update your client's declaration, you can provide more evidence, and you basically get, the most important thing, I think, is that your client then gets another opportunity to testify about their case. And I think evidence is even more important in immigration court, because at this point you're building your record. Everything that you submit in immigration court will then go forward in the case if the case is denied. So if the case goes up to the Ninth Circuit, basically everything you submit at immigration court will be in that certified record. So you really want to build your record in front of immigration court. And I think where at the asylum office, I'm more nervous about submitting a ton of country conditions evidence, I'm more likely to submit more of that evidence in immigration court, just because I want it to be a part of my client's record. Because then I'm going to, hopefully not, but if I have to, be referring back to that evidence on appeal. So, you know, if you get a client who had an affirmative case, hopefully they will bring to you what they submitted to the asylum office, so you can see it and make sure it's all consistent. If they don't have it, then you can do a FOIA request. And I always request asylum officer notes. If you don't specifically request them, they won't necessarily give them. So make sure you specifically request asylum officer notes. The same goes for if your client is in immigration court and they had a credible fear interview. You can go back and say, I would like credible fear interview notes. Hopefully your client will have those when they come to you, but if they don't, you can request them. And it's very important that you get those notes, because again, the government can go back and say, well, you said this in your credible fear interview, why are you saying this now? And so consistency at the immigration court stage is very important. And let's go to the next slide. So, as I was saying, consistency is important, and that's basically because the judge assesses your credibility. The asylum officer also assesses credibility, but they don't make a formal finding of credibility. But immigration judges do. That's like the first part of their decision, is reviewing credibility and saying that they found the client credible, or if they don't find them credible, explaining the reasons they didn't find them credible. And there is a huge body of law on adverse credibility determinations. Whew, you really don't want your client to be found to not be credible by the immigration judge. So this is very important at this stage. It's really, really important. I can't emphasize it enough, because it's really hard to come back from an adverse credibility determination once it's been made, because the immigration judge is given a lot of deference in how they made that determination. So in addition to credibility, you know, and making sure your client is consistent kind of across the board with everything that's happened before and that's happening going forward, you also need to continue to corroborate the claim. So corroboration becomes even more important in immigration court again. So even if your client is found credible, the immigration judge could say, well, you know, they haven't corroborated this, and so that's enough for me to deny the case. So you need to, at this stage, if your client didn't really corroborate stuff at the asylum interview, at this point you need to be like, okay, this is what I need from you to corroborate this case. You know, I need people in your home country to write something. And it may be that you get to court and the judge says, well, you know, I don't believe these affidavits that you wrote or that your family members wrote from your home country. But if you didn't submit them in the first place, then the immigration judge will say, well, you didn't submit any corroborating evidence. So it's better for your client to have some corroborating evidence than none, for sure. Okay, so that's one really important thing that you will have to work on. Next slide. So this is just some details about the immigration court process. So after your client is referred to immigration court, or after they've had their credible fear interview and they're put in immigration court, kind of formally put in immigration court proceedings, or they've had their RFI and been found to have a reasonable fear, and then that all kind of becomes the same process at that point, where every person has a master calendar hearing. Okay, so that's the first hearing. Everyone has it. Your client may have a couple of these hearings, depending on how prepared your client is. If a person goes to a master calendar hearing and they don't have an attorney, the judge is supposed to say, do you want time to find an attorney? And if the person says yes, then they're given another master calendar hearing date, when the judge will say, okay, I want you to come back with an attorney on the next hearing date. If you don't, we'll have to proceed without an attorney. Sometimes if you go back and you still don't have an attorney, they'll give you another master calendar hearing. But, you know, depending on, you know, really how prepared you are, you could have a couple of these. And it may be that you go to the master calendar hearing and you're prepared to take pleadings and you're really ready to go. If you're not ready to take pleadings, you can say, I need time to review the pleadings, and they'll give you another master calendar hearing. If you're prepared to submit an application or an updated application, or know what you're going to do with the case, then probably what will happen at that master calendar hearing is you'll review the notice to appear. You'll say whether your client wants to contest or deny the charges, or agree with them and concede removability. And then after the judge takes pleadings, you state what relief is available to the client. So if it's someone who already applied for asylum, you'd say that they're continuing their asylum application. If they have not filed an asylum application yet, you will have the asylum application ready to file in immigration court. You need to give the original to the immigration judge, and then you have to serve a copy on the government. That's how it works with everything. Original to the court, copy to the government, and keep a copy for yourself. Next slide. So after you have your master calendar hearing or a couple hearings, basically at that master calendar hearing, the judge will say, are you ready to go to trial? If you are, and this could get a little bit complicated if your client has applied for asylum and they don't have 180 days since they applied and they don't have a work permit yet. So if that's the case where you have a client who applied for asylum less than 180 days ago, and you want them to get a work permit, you basically have to say you want an expedited hearing so that that clock can keep running for them to get a work permit. If you say, I'm ready to go to trial, but I want a hearing 5 years from now, then basically you're cutting off chances for your client to get a work permit. So that is a very important detail to remember when you're at your master calendar hearing. But hopefully the asylum ideally the asylum application would have been filed with the court, and you can file it at the court window before the hearing. Hopefully it would have been filed way before your master calendar hearing, so your client has their work permit when they walk into the hearing, and so you'll have plenty of time for their individual calendar hearing. So walking out of a master calendar hearing, you'll get an individual calendar hearing notice. It could be 5 months from now. It could be 3 years from now. I have some hearings in 2021. I have some hearings in 2019. I have a hearing in November that was just set last week. So it's really all over the place when you can get these individual hearings, but you will know at the end of that master calendar hearing when it is. So in preparing for your individual calendar hearing, you have to know the deadline, which the judge will say at the hearing. One judge in Seattle says it's due 10 days before, and I believe all the judges in Tacoma say 10 days. You have to submit everything 10 days before your hearing. The immigration, I think it's the handbook, the immigration court handbook says the deadline is 15 days. Another judge says 2 weeks. So you need to listen at your hearing when the judge says the materials are due, but usually they're due in that 10 to 15 day time frame before. If they don't say, then you default to the 15-day deadline before the individual hearing. And so what do you need to submit by that deadline? I mean, obviously you can submit it before 15 days. I mean, you can submit it way in advance of that if you're organized, but that is kind of the last time when you can submit it in a timely manner. So usually what I submit by that day, my legal brief, which I call the pre-hearing memo, and then my index of documents, which I call my pre-hearing statement. And in the pre-hearing statement, I list my witnesses, and I list how long they'll testify for and how they'll testify in what language. And then how that hearing proceeds usually is the judge will review the evidence that's been submitted. The client will testify. They'll do direct examination, and then the government will cross-examine them. There may be redirect. The judge may ask some questions, and then you do the same thing with other witnesses: direct, cross-examine, redirect. And sometimes the government will have people testify, which is always exciting because then you can do cross-examination. And the judge basically can chime in at any time and ask questions, and most of them do. And at the end of the hearing, if the judge knows what they're doing, they will give an oral decision. Sometimes they don't know what they're doing, and they'll say, we're going to issue a written decision. And so at that point, you just wait for a decision. Next slide. So what happens after immigration court? If the judge does issue an oral decision, they'll ask if the parties waive appeal or not. So I recommend never waiving appeal if the judge has denied your client's case. You know, if they've granted, then you say, oh, I don't, you know, I don't waive it. And then you hope that the government will waive appeal as well. Because if they waive appeal, then the decision is final. If they don't waive appeal, then you basically have to wait 30 days to see if they appeal your client's decision. If you decide to appeal, then you have 30 days to file the notice of appeal with the Board of Immigration Appeals, which is the court in Virginia. And if the notice of appeal, it's available on the EOR website. It's like a 5-page form, and it gives you all the information about what you need to fill out. It's pretty straightforward. You just need to get that form plus a copy of the decision within 30 days to Virginia. Okay, if you miss that deadline, client's out of luck, right? So it's just very important to be on top of that appeal deadline because it's not a lot of time. Okay, next slide. So filing an appeal with the BIA. Like I said, you submit the form E26 with the reasons of the basis of the appeal and attach the order of the immigration judge. And if you have a copy of the decision, include a copy of the decision. If you're the attorney, you need to submit an E27. And I should have said, if you are entering your appearance in immigration court, you need to submit an E28 to let the court know that you're entering your appearance. But for the BIA, it's a different form. It looks exactly the same as the E28, but it's for the BIA. It needs to be received by the BIA by 30 days. Okay, so if you can't send it on the 30th day, you have to send it, I prefer a week in advance, just so that you have plenty of time. If you need to file it same day, there are organizations that will help you do that, and it's totally worth it, just to preserve your client's right to appeal. Next slide. After you file the appeal, you'll get a receipt acknowledging that they received the notice of appeal with the payment. And then you wait a little bit, and then the BIA will send a transcript of the proceedings. And so they're not going to send you a copy of the pre-hearing statement or a copy of the pre-hearing memo. That's not going to be included with what they send you. You have to have your own copy of that. If you don't have a copy of that, you either need to FOIA it or you need to get it from the prior attorney if they had a prior attorney. So, but you will get the transcript, which is everything that was said in immigration court, so that you can go back and look over the testimony, look over the decision, and find issues, hopefully, with the immigration judge's decision that would give the reason to the BIA to overturn that decision or remand it to the immigration judge. And with the transcript, they send you a briefing schedule. It will state the date you have to submit your brief, and also the day the government has to respond to your brief. And usually the briefing schedule is pretty fast, so every person gets an automatic 21-day extension if you request it. So you just need to send a request for a 21-day extension when you get this briefing schedule, and they'll grant it. You'll get 21 more days after the original due date, so you'll have a little bit more time. Extensions after that, I think, are fairly rarely granted. So plan to submit your brief by at least the second deadline. Next slide. Okay. And after the BIA, if the BIA dismisses your appeal, which, you know, their appeals are taking a while. I mean, they're all over the place, how long they're taking. I've had some take a couple months, and then I've had some take a year or 2 years. Motions to reopen are taking about 6 months. So, you just need to make sure if you move or your client moves that you keep your address up to date with the BIA, because you don't know when they're going to issue that decision. But basically, you'll get it in the mail, and there'll either be a decision sustaining or dismissing your appeal. If they sustain, they'll remand it to the immigration judge and give reasons why it was remanded. And then your client will have another chance before the immigration judge. If they dismiss your appeal, then your next option is to submit a petition for review. There's a $500 filing fee for the petition for review with the U.S. Court of Appeals of the Ninth Circuit. And you have a hard 30-day deadline for submitting that petition for review from the date of the denial from the BIA, right? So that's another 30-day hard deadline. If you miss that deadline, it's clear ineffective assistance of counsel. If your client isn't going to hire you to do that, you need to tell them, this is your deadline. If you miss it, this is what happens. You don't tell them about your deadline. It's also very problematic. So, that's the main thing to know once you get your BIA decision. And of course, we have, if your client's case was decided in the Seattle Immigration Court, then it's an issue of venue. So because the Seattle Immigration Court is in the Ninth Circuit has jurisdiction over that appeal. If your client's case was decided in San Antonio Immigration Court, then your client's venue, the venue for the appeal, is in the Fifth Circuit, right? So you do need to know, obviously, where the immigration court was in order to know where to file the correct appeal. Next slide, please. So obviously you guys know this is a different audience than I did this presentation for before, but basically the U.S. Courts of Appeal have exclusive jurisdiction to review final orders of removal. And so that's one thing that can come up, is that sometimes the government will argue this isn't a final order of removal for some reason. But most cases, if you have a decision by the BIA dismissing a case or denying a motion to reopen, it can be reviewed by the U.S. Court of Appeals. There are some issues that the Court of Appeals have said that they don't have jurisdiction over discretionary decisions, and that's just something you need to know when you are doing those cases. And obviously, you have to be admitted to practice before the Ninth Circuit before you can file with them. As opposed to the BIA. I mean, with the BIA, there is an e-registry thing that you're supposed to do, but if you're not set up on e-registry, I think you can still file in front of the immigration court and BIA. And I think you need to go through that process, but it's not like you have to be admitted to practice in front of the BIA or the immigration court. And obviously, in the Ninth Circuit, we have e-filing, which is so wonderful, as opposed to the paper filing with the BIA and the immigration court, which may be changing in the near future. We just got a notice that they're going to start doing some e-filing finally with the BIA and the immigration court, but Seattle is not a pilot court, so we'll have to wait a little bit longer for that. Next slide. So, if for those people who haven't done federal court appeals, after you file the petition for review, and actually I should say that with the petition for review, you'll need to file a stay of removal for your client to make sure that their deportation is stayed while their petition for review is pending. It's automatically stayed, their deportation is automatically stayed while their BIA case is pending and the immigration court case is pending, but once BIA dismisses the appeal, it's not automatic. So you do need to file a stay of removal with the Ninth Circuit Court of Appeals. And luckily, the Ninth Circuit gives you a temporary stay as soon as you file that stay of removal. So you can kind of rest easy that your client's not going to be deported until the stay of removal is adjudicated. And that usually happens a little bit later after you've filed the petition for review. So the government will have to produce the certified administrative record, which is great. It's so great having the certified administrative record. It's all in one document. Everything's there. And you can't rely on documents outside of that record. That's the only downfall of the certified record, is that you can't then introduce new evidence at that point. And you can't introduce new evidence once the case is at the BIA either, which is why it's so important for you to submit as much as you can at the immigration court level. And once the certified record's been produced, the court will issue a briefing schedule. You know, at that in there, the government may not oppose your stay of removal, and then you'll have a stay of removal in place the whole time the petition for review is pending. And then you'll have to submit your opening brief, and the respondent, the government will submit their brief, and then I always submit a reply brief. I've heard that if you don't, the government will think you don't care about your client, so, or the judges will think you don't care about your client. So I think that's best practice to do that. Next slide. So, you know, I have, for others who may do federal court work, I don't know if it's the same for non-immigration cases, but for immigration cases, these cases are taking about 2 to 3 years. I have an oral argument for a case coming up that I filed in 2015. So yeah, it's been a few years. And really, you just kind of wait after you've done the briefing, and hopefully during that time you're thinking with your client about other options they may have, because if the case doesn't get scheduled for oral argument, you know, they don't really have a lot of chance of prevailing. So usually at this point, I'm thinking about backup options for my client. Maybe asylum isn't going to work. So let's think about what other options you may have, and what we're going to do if your case is denied. Next slide. So the Ninth Circuit could grant the petition and remand it to the BIA or IJ for further on an open record, or on a new decision, which is the best outcome for your client. Or they could deny the petition and dismiss the appeal. If the appeal is dismissed, the client has reached basically the end, with a few exceptions. The only option at that point is to file a stay of removal with ICE, or if they don't have any applications pending, like a U visa, or they're married to a U.S. citizen. You know, at that point, you kind of have run out of your options. So that becomes a time when we start, if they haven't filed it already, you may have an option of filing something called a motion to reopen. Okay, so that's that's the end of my presentation. But that was just a quick overview of kind of from the beginning to end of what an asylum case can look like, starting from the interview up into the Ninth Circuit. And I didn't get into a lot of specifics about the pre-hearing statement or what you have to prepare for court, but I'm sure the attorneys you're working with have a lot of samples, and I'm sure Northwest Immigrant Rights Project has a lot of samples that they can share for how you prepare those documents. We also have, I'm sure they have briefs they can share, and there are a lot of practice advisories out there, you know, about matter of AB and how to address arguments based on that case. And so, you know, there's no reason to recreate the wheel if someone has already worked on a similar issue. You know, hopefully at some point you'll have templates, your own templates created, and you can use previous briefing you've done and apply it to your client's case. And like I said in the last training, the Ninth Circuit Immigration Outline is always helpful. It's really an amazing resource. So there are lots of different resources for you, but if you need specific samples, I'm happy to share them as well if the mentor attorneys haven't provided them. If you have any questions, you can contact me at my email. Thank you.